In this module, I want to talk about substantive due process and equal protection. Specifically, I want to focus on three topics. First, I want to talk about the levels of scrutiny that are so important whenever courts are dealing with individual liberties or equal protection under the Constitution. Second, I want to talk about substantive due process and the rights that are protected under it. And then third, I want to talk about equal protection, the framework for analysis, and how it's applied. So my first topic then is the levels of scrutiny. Whenever a court is dealing with individual liberties or equal protection of the Constitution, the outcome very much depends on the level of scrutiny. There are three levels of scrutiny, and over the course of this hour, I'll be discussing when each is applied. First of the levels of scrutiny is the rational basis test. Under the rational basis test, a law is upheld if it is rationally related to a legitimate government purpose. Under the rational basis test, a law is upheld if it is rationally related to a legitimate government purpose. Notice that the government's goal just has to be something that's permissible, legitimate for the government to do. The court doesn't even insist that the government's actual purpose be legitimate. So long as there is a conceivable legitimate purpose, that's sufficient. Under the rational basis test, courts are tremendously deferential to the government. The government usually wins under rational basis review. And so, as one might expect, under rational basis review, the challenger has the burden of proof. That is, under rational basis review, a law will be struck down only if the challenger can show either that there's no conceivable legitimate purpose or that the law is not rationally related to it. Under rational basis review, since the challenger has the burden of proof, the law will be upheld unless the challenger show either that there's no conceivable legitimate purpose or that the law is not rationally related to it. So what do you really need to remember with regard to rational basis review? The test, rationally related to a legitimate government purpose, and the challenger has the burden of proof. The second level of scrutiny is intermediate scrutiny. Under intermediate scrutiny, a law will be upheld if it is substantially related to an important government purpose. Under intermediate scrutiny, a law will be upheld if it is substantially related to an important government purpose. Notice that the government's goal must be more than just something that's legitimate for the government to do. The court has to be persuaded that the government's objective is an important one. Here, the court will look only at the government's actual purpose. The court must be convinced that the government's actual objective is important. The means chosen must be substantially related to achieving the end. Sometimes courts say that this means that the technique of the government, the law involved, has to be narrowly tailored to achieving the objective. I think the easiest way to understand this is the means chosen by the government has to be a very good way to achieve the objective. It has to be narrowly tailored. It has to be substantially related. But under intermediate scrutiny, it doesn't have to be the best way. Least restrictive alternative analysis is not used under intermediate scrutiny. The means have to be substantially related, a very good way, but they don't have to be the least restrictive alternative. It's now clearly established that under intermediate scrutiny, the challenger has the government has the burden of proof. Under intermediate scrutiny, the government has the burden of proof, meaning the law will be upheld only if the government can convince the court that its action is substantially related to an important government purpose. So what do you really need to know about intermediate scrutiny? The test, substantially related to an important government purpose, and remember, it's the government that has the burden of proof. The final level of scrutiny is strict scrutiny. Under strict scrutiny, a law will be upheld only if it is necessary to achieve a compelling government purpose. Under strict scrutiny, a law will be upheld if it is necessary to achieve a compelling government purpose. Notice that the government's goal has to be more than just something that's legitimate, more than this that's important for the government to accomplish. The court has to be persuaded that the government's objective is crucial, vital, compelling. The means chosen must be shown to be necessary to achieve the goal. Under strict scrutiny, like under immediate scrutiny, the court will look only at the government's actual purpose. A conceivable purpose isn't good enough. Additionally, the court's got to be persuaded that the means are necessary to attain that objective. This is where least restrictive alternative analysis is used. In order to meet strict scrutiny, the government has to show that there's no less restrictive alternative that can achieve its objective. Under strict scrutiny, like under immediate scrutiny, the means have to be narrowly tailored to achieve the objective. But more than that is required under strict scrutiny. Under strict scrutiny, the means must be necessary. The government has to show there's no less restrictive alternative to achieve its objective. Strict scrutiny is the most exacting type of review. The government usually loses under strict scrutiny. It shouldn't surprise you then that under strict scrutiny, like under immediate scrutiny, it's the government that has the burden of proof. Under strict scrutiny, the law will be upheld only if the government can show that it's necessary to achieve a compelling government purpose. So what do you need to know about strict scrutiny? Necessary to achieve a compelling government purpose. Remember, the government has the burden of proof. With the levels of scrutiny in mind, I now want to move to the second part of this module, and I want to look at substantive due process. Let me start with a definition. Substantive due process asks whether the government has an adequate reason for taking away a person's life, liberty, or property. Substantive due process asks whether the government has an adequate reason, a sufficient substantive justification for taking away a person's life, liberty, or property. On another module, I discussed procedural due process. That refers to the procedures that government must follow. Substantive due process asks whether the government's got a good enough reason for infringing the person's right. Obviously, what's a sufficient reason will depend on the level of scrutiny used, and that, of course, turns on the right involved. I find that students sometimes have difficulty in separating procedural and substantive due process. So let me give you an easy example to keep in mind. The Supreme Court has said that parents have a fundamental right to the custody of their children. If the state wants to permanently terminate custody, it's got to meet both procedural and substantive due process. Procedural due process requires that the government provide notice and a hearing before it permanently terminates rights. Substantive due process requires that the government show a compelling need to terminate rights. It has to prove parental abuse or neglect. I am focusing now on substantive due process. Substantive due process has been used as a way of describing, of protecting a number of liberties. A, the Constitution provides only minimal protection for economic liberties. In beginning my discussion of substantive due process, I start with A, the Constitution provides only minimal protection for economic liberties. There was a time in the 20th century, before 1937, during a period of constitutional law known as the Lockton era, where the Supreme Court aggressively protected economic liberties. During the Lockton era, the Supreme Court essentially said that freedom of contract was a fundamental right, and the court essentially used strict scrutiny if the government interfered with freedom of contract. But since 1937, the courts overruled all of those Lochner decisions. Since 1937, the Supreme Court has said it's only rational basis review when the government interferes with economic liberties. So, for example, if you would ever have a test question where it's a due process challenge to a minimum wage law or maximum hour laws, employment regulation, the correct answer is rational basis review and the government wins. When there's a due process challenge to state laws that regulate trades or professions, and people claim a right to practice their trade or their profession, it's rational basis review, and the government's going to win. When there's a due process challenge to consumer protection laws, like the requirement that people pass a bar exam in order to be lawyers, it's rational basis review, and the government wins. I'm sorry to have to tell you that prospective lawyers have brought every imaginable constitutional challenge to bar exams, and the challenges never succeed. When it comes to due process challenge to government economic regulations, it's only rational basis review. Now, whatever protection there is of economic liberties under the Constitution since 1937 has come under other specific constitutional provisions. There's the Contracts Clause of Article 1, Section 10. There's the Takings Clause found in the Fifth Amendment. I've covered those in a different module. Here I'm focusing on due process challenges to economic regulations. Only a rational basis test is used. The Constitution provides minimal protection for economic liberties. Sub B is the right to privacy. For almost a century, the Supreme Court has said that privacy is protected as a fundamental right under the liberty of the Due Process Clause. Therefore, generally, strict scrutiny is used when the government interferes with privacy rights. In reality, privacy is an umbrella that's used to describe a number of specific liberties. Let me cover for you the aspects of privacy that are protected by the Constitution. Point 1. The right to marry is a fundamental right. The Supreme Court has said, as recently as June 26, 2015, that the right to marry is safeguarded as a fundamental right under the liberty of the Due Process Clause. Before June 26, the Supreme Court had said that the right to marry is a fundamental right for opposite couples. And on June 26, in Oberfeld versus Hodges, the Supreme Court said that state laws that prohibit same-sex marriage violate the right to marry and therefore are unconstitutional. So now the law is clear that the right to marry is a fundamental right, both for opposite sex and for same-sex couples. Point 2 with regard to privacy. The right to procreate is a fundamental right. Therefore, for example, the government can impose involuntary sterilization only if it meets strict scrutiny, only if it shows that its action is necessary to achieve a compelling government purpose. Point 3. The right to custody of one's children is a fundamental right. I mentioned this in discussing the definition of substantive due process, and so, because the right to custody of one's children is a fundamental right, substantive due process requires that the government prove a compelling reason before permanently terminating parental custody. It would have to prove parental abuse or parental neglect. One qualification with regard to the right to custody: the Supreme Court has said that a state can create an irrebuttable presumption that a married woman's husband is the father of her child. A state may create an irrebuttable presumption that a married woman's husband is the father of her child. This was the holding in Michael H. versus Gerald D. in 1989. Michael H. versus Gerald D. had facts that a made-for-TV movie could be made from. A woman who the court described as an international model had an affair. She was married. She conceived a child as a result of the affair. She didn't divorce her husband, but she moved in with the biological father and lived with him for 18 months. After about a year and a half, she left the biological father and rejoined her husband. She took the child with her. The biological father sued for visitation rights. However, at this time, California had a law that said if a married woman had a child in these circumstances, there was an irrebuttable presumption that the married woman's husband was the father of her child. The California court used this law to deny all parental rights, including all visitation rights, to the biological father. The Supreme Court upheld the California law in its application. The Supreme Court said a state may create an irrebuttable presumption that a married woman's husband is the father of her child. Point 4. The right to keep the family together is a fundamental right. I list the right to keep the family together separately because family is broader than parents and children. It includes the extended family. You might remember here the case Moore versus City of East Cleveland. East Cleveland, Ohio had a zoning ordinance that limited the number of unrelated people who could live in the same household. The way unrelated was defined, it kept a grandmother from living with her two grandsons who were first cousins. The Supreme Court declared the East Cleveland ordinance unconstitutional. The court proclaimed that there's a fundamental right to keep the family together, and that includes the extended family. I hasten to add, though, that in order to be considered a family, individuals must be related to one another. You might remember another case here, Village of Belterre versus Boras. The Village of Belterre is the State University of New York at Stony Brook is located. It also had a zoning ordinance that limited the number of unrelated people who could live in the same household. In this case, it was college students who wanted to share a house who brought a challenge. They lost. The zoning ordinance was upheld. So what's the difference between these two cases? In Moore, it was relatives, grandmother and grandchildren. In Belterre, it was college students who were not related to one another. Point 5, with regard to privacy. Parents have a fundamental right to control the upbringing of their children. Parents have a fundamental right to control the upbringing of their children. The government can interfere with parenting decisions only if it meets strict scrutiny. As an example here, in the 1920s, the Supreme Court ruled that parents have the right to send their children to parochial schools. The court found a law prohibiting parochial school education unconstitutional based on its interference with the right of parents to control the upbringing of their children. More recently, the Supreme Court said it violates due process for a court to order grandparent visitation over the parent's objections. It violates due process for a court to order grandparent visitation over the parent's objections because it violates the right of the parent to control the upbringing of the child. Point 6. The right to purchase and use contraceptives is a fundamental right. At the risk of the worst pun of all, I'm sure you remember the seminal case of Griswold versus Connecticut, where the Supreme Court initially said there's a fundamental right to purchase and use contraceptives. Wouldn't want there to be any misconceptions here. The Supreme Court has approved strict scrutiny for this right. Point 7, the right to abortion. As you know, in Roe versus Wade in 1973, the Supreme Court held that women have a fundamental right to choose whether to terminate their pregnancies. By the 1990s, there was a good deal of uncertainty as to whether Roe would be overruled. In 1992, in Planned Parenthood versus Casey, the Supreme Court reaffirmed Roe versus Wade, but the court significantly changed the law with regard to abortion. No longer is strict scrutiny used for abortion rights. Strict scrutiny is used for all of the other rights under privacy that I've thus far discussed, but not for abortion. Here's the current law with regard to abortion. Sub A, prior to viability, the government cannot prohibit abortions. the government may regulate abortions so long as not place an undue burden on the right. Prior to viability, the government cannot prohibit abortions. The government can regulate abortions so long as not place an undue burden on the right. Viability is the time at which the fetus can survive outside the womb. In Planned Parenthood versus Casey, the Supreme Court reaffirmed, prior to viability, the government cannot prohibit abortions. But the court said the government can regulate abortions so long as not place, quote, an undue burden on the right. In other words, the so-called undue burden test has replaced strict scrutiny in evaluating government regulation of pre-viability abortions. The court has never defined the undue burden test with any precision, but it's ruled on a few examples you should know about. One example is that the court has said that a 24-hour waiting period for abortions is not an undue burden. It is constitutional. The court has said requiring that a woman wait 24 hours after requesting an abortion before one is performed is not an undue burden. Another example, a requirement that abortions be performed by licensed physicians is not an undue burden. It is constitutional. A requirement that abortions be performed by licensed physicians is not an undue burden. It is constitutional. Final example here, a prohibition of so-called partial birth abortions is not an undue burden. It is constitutional. A prohibition of partial birth abortions is not an undue burden. This was the holding Gonzalez versus Carhart in 2007, where the Supreme Court upheld the Federal Partial Birth Abortion Ban Act. This was a law that made it a crime to remove a substantial part of a living fetus or a living fetus with the intent of ending the fetus's life. The Supreme Court found that the law was constitutional. After viability, the government may prohibit abortion except where necessary to protect the woman's life or health. After viability, the government may prohibit abortion except when necessary to protect the woman's life or health. Sub B, the government is never constitutionally required to subsidize or provide facilities for performing abortions. The government is never constitutionally required to subsidize or provide facilities for performing abortions. There have been 6 Supreme Court cases at this, and all have come to the same conclusion. The government never is required by the Constitution to pay for abortions, and the government never has to provide facilities like public hospitals for performing abortions. Sub C, spousal consent and spousal notification laws are unconstitutional. Spousal consent and spousal notification laws are unconstitutional. In other words, a state cannot condition a married woman's receiving an abortion on her having to first get consent from her husband. Nor can a state condition a married woman's abortion on her having given notice to her husband. The right to abortion is each woman's to make, and no one, the husband, has to give consent or even be notified before this right is exercised. And finally, sub D concerns parental notice and or consent requirements for unmarried minors' abortions. With regard to parental notice and or consent requirements for unmarried minors' abortions, the Supreme Court has held that a state may require parental notice and or consent for an unmarried minor's abortion, but only if it creates an alternative procedure where a minor can obtain an abortion by going before a judge. The judge can approve the abortion either by finding it be in the minor's best interest or by concluding she's mature enough to decide for herself. A state may require parental notice and or consent for an unmarried minor's abortion, but it must provide an alternative procedure where a minor can obtain an abortion without parental notice consent, by the minor going before a judge. And the judge can approve the abortion either by finding in the minor's best interest or by concluding that she's mature enough to decide for herself. Point 8. The right to privacy includes the right to engage in private, consensual, adult homosexual activity. The right to privacy safeguards the right to engage in private, consensual, adult homosexual activity. This was the holding of Lawrence versus Texas in 2003. There, the Supreme Court declared unconstitutional a Texas law that prohibited homosexual activity. The court did not indicate the level of scrutiny that it was using for this right. But the court made clear state laws that prohibit private, consensual, adult, same-sex sexual activity violate the liberty of the Due Process Clause. The court explained, if privacy means anything, it's what consenting adults do in their own bedroom. Point 9, the right to refuse medical treatment. There's only been one Supreme Court case about the right to refuse medical treatment. It was Kruzan versus Director of Health Services in 1990. There were 3 parts to the court's holding in Kruzan. Sub A, competent adults have a right to refuse medical care, even life-saving medical care. Competent adults have a right to refuse medical care, even life-saving medical care, even food and water. 8 of the 9 justices on the court, all but Justice Scalia, agreed that such a right exists. Here, too, though, the court didn't identify the level of scrutiny that it was using. It said in the liberty of the Due Process Clause, competent adults have a right to refuse medical care, but the court didn't say what level of scrutiny is to be used for this right. Sub B, a state may require clear and convincing evidence that a person wanted treatment terminated before it is ended. A state may require clear and convincing evidence that a person wanted treatment terminated before it is ended. The court explained that the government has an important interest in safeguarding the sanctity of life, so a state may require that there be clear and convincing evidence that the person wanted treatment terminated before it is cut off. And sub C, a state may prevent family members from terminating treatment for another. A state may prevent family members from terminating treatment for another. The court explained that the right to refuse treatment belongs to each individual. The court said a state might believe that family members have a conflict of interest, that they want to cut off treatment to reduce their own emotional or financial burdens. And so the court said that a state may intervene to prevent family members from terminating treatment for another. Finally, with regard to privacy, point 10, the right to privacy does not include a right to physician-assisted death. The right to privacy does not include a right to physician-assisted death. This was the holding of Washington versus Glucksberg in 1997. This was a lawsuit by terminally ill patients in Washington state challenging the Washington law that prohibited aiding or abetting a suicide. The terminally ill patients argued that the right to privacy should include a right to death with dignity. The Supreme Court, though, rejected such a claim, said the right to privacy does not include a right to assisted death. Thus far under substantive due process, I've considered economic liberties and privacy. These are the 2 main areas where the Supreme Court has used substantive due process. What I want to do now is continue the discussion of rights and consider 3 rights that are quite important to know about, but they've not been primarily protected in a substantive due process. The court has been more amorphous about where some of these are protected in the Constitution. So while economic liberties was A and privacy was B, C here is the Second Amendment. The Second Amendment says, a well-regulated militia being necessary to a free state, the right of the people to keep and bear arms shall not be infringed. From 1791, when the Second Amendment was adopted, until 2008, The Supreme Court had always said that the Second Amendment protects a right of people to have guns for the purpose of militia service. But this changed in 2008. The case was District of Columbia versus Heller. It involved a 35-year-old District of Columbia ordinance that prohibited private ownership possession of handguns. In a 5-4 decision, the Supreme Court declared this unconstitutional. The Supreme Court said, at the very least, the Second Amendment protects the right of individuals to have guns in their home for the sake of security. It's important to note that the court did not identify the level of scrutiny that it was using for this right. But the court did make clear that this right is not absolute. The court said, for example, the government can regulate who has guns, keeping those with a felony conviction or a history of serious mental illness having guns. The court said the government can regulate where people have guns, preventing guns in places like schools and airports. The court said the government can regulate what type of guns people have, like keeping people from having military weapons like bazookas. In 2010, in McDonald versus City of Chicago, the Supreme Court said this right applies to state and local governments by being incorporated into the Due Process Clause of the 14th Amendment. So to this point, that's all we know about the Second Amendment. What the Supreme Court said in District of Columbia versus Heller in 2008, McDonald versus Chicago in 2010. The Second Amendment includes a right of people to have guns in their home for the sake of security. The court has not specified the level of scrutiny to use for this right, but the court has made clear that the government can regulate who has guns, where they have guns, and what types of weapons they possess. Major subpoint D under substantive due process is the right to travel. The Supreme Court long has declared that the right to interstate travel is a fundamental right. Some of these cases have used equal protection as the place for finding the right to travel. A more recent case in 1999, Sines versus Roe, found that the right to travel is safeguarded under the Privileges or Immunities Clause of the 14th Amendment. Whether the right to travel is linked to equal protection with the Privilege and Immunities Clause or the liberty of the Due Process Clause, the same rules apply. Point 1. Laws that prevent people from entering or leaving a state must meet strict scrutiny. Or to put this another way, laws that keep people from moving into a state must meet strict scrutiny. Key case here arose during the Depression. California adopted a law that said a person could not move into California unless the individual could prove the means for supporting himself or herself. The Supreme Court declared this law unconstitutional and said that it violates the fundamental right to interstate travel and migration. It infringes the right to travel. Point 2. Durational residency requirements must meet strict scrutiny. Durational residency requirements must meet strict scrutiny. A durational residency requirement is where a person must live in a jurisdiction for a specified amount of time in order to get a benefit. The Supreme Court has explained that a durational residency requirement will chill interstate travel and migration, and thus it must meet strict scrutiny. The most famous case here was Shapiro versus Thompson 45 years ago. Pennsylvania had a law that said that in order for a person to receive welfare benefits in the state, the individual had to first live in the state for a year. The Supreme Court declared this unconstitutional. The court said that the right to travel is protected as a fundamental right under equal protection. The court said the Pennsylvania law would unduly chill and restrict interstate migration. The court used strict scrutiny and declared the Pennsylvania law unconstitutional. One qualification about this, the Supreme Court has said that for voting, 50 days, 5-0, is the maximum allowable durational residence requirement. For voting, 50 days is the maximum allowable durational residency requirement. I grew up in Chicago, which is famous for its graveyard vote. My dad died over 20 years ago, but I think he is still voting in Chicago elections. The Supreme Court said, in light of election practices like that, voter officials need time to check the voter rolls, to make sure they still live in the area, they're still alive. But the court has said 50 days is the maximum allowable durational residency requirement for voting. In point 3, only a rational basis test is used for restrictions on foreign travel. Only a rational basis test is used for restrictions on foreign travel. The Supreme Court has said there is not a fundamental right to international travel. Restrictions on foreign travel only have to meet rational basis review. Sub E is the right to vote. The right to vote. The 15th Amendment says that the right to vote shall not be denied on account of race. Additionally, the Supreme Court has long protected the right to vote as a fundamental right under equal protection. Again, whether the right to vote is protected under the 15th Amendment or under equal protection, or for that matter, due process, the results are the same. The analysis is the same. To be specific with regard to the right to vote, point 1, laws that prevent some citizens from voting must meet strict scrutiny. Laws that prevent some citizens from voting must meet strict scrutiny. Example, poll taxes. The requirement that people pay a fee in order to vote are unconstitutional. The Supreme Court said a poll tax, a fee for voting, would keep some citizens from voting. The court used strict scrutiny and declared it unconstitutional. Another very important example is that property ownership requirements for voting are almost always unconstitutional. Property ownership requirements for voting are almost always unconstitutional. A leading Supreme Court case here involved a city that had an ordinance that said, in order to vote in city school board elections, a person either had to own property in the city or have children in the city schools. The Supreme Court declared that unconstitutional. But one qualification here. Laws that are designed to protect the integrity of the electoral system will be held if they are on balance desirable. Laws that are designed to protect the integrity of the electoral system will be upheld so long as they are on balance desirable. This is a case that involved an Indiana law that required that voters show photo identification in order to vote. The claim was that this would keep some citizens from voting. The Supreme Court, in Crawford versus Marion County, Indiana in 2008, upheld the law. There was no majority opinion for the court. Justice Stevens' opinion said that this is a law that's designed to protect the integrity of the electoral system. It's designed to prevent fraud. He said it should be allowed because it's on balance desirable. He said the benefit in stopping fraud and in preserving confidence in the electoral system outweighs the burdens with regard to the right to vote. So generally, when the government interferes with the right to vote, the government has to meet strict scrutiny. But if it's a regulation designed to protect the integrity of the electoral system, it will be allowed so long as it's on balance desirable. Point 2. One person, one vote must always be maintained. One person, one vote must always be maintained. This means for any legislative body with districts, all districts must be about the same in population size. For any legislative body that has districts, all districts must be about the same in population size. Prior to the 1960s, many state legislatures were badly malapportioned. You might have a legislature where in one district, 25,000 people elected a representative, and then in another district where 100,000 people elected a representative. Those in the latter district were obviously disadvantaged. Thus, the court announced the rule, one person, one vote. For any legislative body, city council, state legislature, United States House of Representatives, where there are election districts, all of the districts must be about the same in population size. Point 3, at-large elections are allowed unless there's proof of a discriminatory purpose. At-large election systems are allowed unless there's proof of a discriminatory purpose. An at-large election system is where all of the voters vote for all of the office holders. To understand this, consider the facts of the leading Supreme Court case, City of Mobile versus Bolden. Mobile, Alabama, had a 3-person city council. It might have, but it didn't, draw the city into 3 election districts and let each district elect 1 representative. Instead, what it had was an at-large election system. Every voter cast 3 votes for the 3-person city council. Mobile at the time of litigation was 2/3 white and 1/3 black. As a result of the at-large election district system, never in the 20th century was an African American elected to the Mobile City Council. Nonetheless, the Supreme Court upheld this as constitutional. The Supreme Court said the at-large system is allowed unless it could be proven that its underlying purpose was to disadvantage African American voters. Point 4. The use of race in drawing election districts to benefit minorities must meet strict scrutiny. The use of race in drawing election districts to benefit minorities must meet strict scrutiny. There have been a number of Supreme Court cases about this. All have held that if the government uses race as a predominant factor in drawing election districts, such as to benefit minorities, create more majority minority districts, the government must meet strict scrutiny. And finally, with regard to the right to vote, point 5, counting uncounted votes in a presidential election without preset standards violates equal protection. Counting uncounted votes in a presidential election without preset standards violates equal protection. This was the holding of an obscure Supreme Court case on June 12, 2000, Bush versus Gore. There, the Supreme Court said, counting the uncounted votes in the Florida presidential election without preset standards how the ballots be treated denied equal protection. Well, having talked about economic liberties, privacy, the Second Amendment, the right to travel, the right to vote, finally, I want to conclude with subpoint F. Education is not a fundamental right under the Constitution. Education is not a fundamental right under the Constitution. This was the holding of San Antonio Board of Education versus Rodriguez in 1973. Rodriguez was a challenge of the Texas system of funding public schools largely through local property taxes. The result was that poor areas had a tax at a very high rate, but had little to spend on education. Wealthy areas could tax at a much lower rate and had far more to spend on education. Nonetheless, the Supreme Court upheld the system as constitutional. The Supreme Court ruled and later reaffirmed that education is not protected as a fundamental right under the Constitution. And that completes my discussion under the heading of substantive due process. I said at the start of this hour that in this module, I want to cover 3 topics. I want to talk about the levels of scrutiny, I want to talk about substantive due process, and finally, third major topic is equal protection. This, of course, is the provision in the 14th Amendment that no state shall deny any person equal protection of the laws. Whenever the government draws a distinction among people, there's the basis for an equal protection challenge.